Parliament Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I do have a further submission to deal with my colleague, the Honourable Member for Promonget, in his intervention on a point of privilege just a few moments ago. Of course, my comments will be restricted to a point of privilege regarding the group Anonymous and not on the WikiLeaks issue, which we just clarified a few moments ago. Mr. Speaker, I'm rising to provide the Chair with additional submissions with respect to the question of privilege, as I mentioned a few moments ago. My honourable friend has put before the House a submission that his rights as a Member of Parliament has been breached with respect to freedom from obstruction, interference, intimidation, and molestation. In particular, Mr. Speaker, his freedom from intimidation in connection with the proceeding in Parliament has been breached, amounting to a contempt. Moreover, sir, I submit that there is a second contempt here in relation to the obstruction of the Honourable Member for Provencher through an interference of nepotism and an accusation of criminal activity. The classic definition of parliamentary privilege can be found at page 75 of the 23rd edition of Erskine May's Treatise on Law, Privileges, Proceedings, and Usage of Parliament. And I quote, Mr. Speaker, "Parliamentary privilege is the sum of the particular rights enjoyed by each House collectively, and by members of each House individually, without which they could not discharge their functions and which exceed those possessed by other bodies or individuals." End quote. More pithy summary of privilege can be found in Mr. Speaker Lamoureux's decision at page 5338 of Debates for April 29, 1971, where he said, again I quote, "In my view, parliamentary privilege does not go so much beyond the right of free speech in the House of Commons and the right of a member to discharge his duties in the House as a member of the House of Commons," end quote. Citation 93 on page 25 of Houchén's Parliamentary Rules and Forms, 6th edition, states that, quote, "It is generally accepted that any threat or attempt to influence the vote of or actions of a member is a breach of privilege," end quote. Citation 99 on page 26 of that adds, quote, "Direct threats which attempt to influence members' actions in the House are undoubtedly breaches of privilege," end quote. While some parts of this situation are time-tested, other characteristics of this case, Mr. Speaker, present novel aspects to contemplate. On the one hand, responding to threats is amongst the first matters of parliamentary privilege dealt with in Canada. Page 198 of the 2nd edition of Joseph Mango's Parliamentary Privilege in Canada tells us of an incident in 1758 where the Nova Scotia House of Assembly proceeded against someone who made threats against a member. Although the framework of privilege has largely solidified through centuries of common law, statutes, and even the Constitution, it continues to have sufficient flexibility to adapt and be applied to a changing environment, such as televising of proceedings, as noted at page 63 of House of Commons Procedure and Practice, the 2nd edition. Page 225 of Mango advises, quote, "While privilege may be codified, contempt may not, because new forms of obstruction are constantly being devised, and Parliament must be able to invoke its penal jurisdiction to protect itself against these new forms. There is no closed list of classes of offences punishable as a contempt of Parliament," end quote. That speaks to the novel aspects in this case, where we are dealing with the publications on the internet, and particularly with videos on the website YouTube. The YouTube videos, Mr. Speaker, of the so-called Anonymous includes comments which are, I would submit, threats and even blackmail. These comments seek to induce the Minister of Public Safety to undertake certain actions in respect of a bill he has introduced and sponsors. Before I press further into my submissions, I want to make it very clear that I do not seek to bring ordinary free and democratic expression or critical speech into what is being considered here. Mr. Speaker, page 235 of Mango offers an articulate review of the balance to be considered. And I quote, "All interferences with members' privileges of freedom of speech, such as editorials and other public comment, are not breaches of privilege, even though they influence the conduct of members in their parliamentary work. Accordingly, not every action by an outside body that may influence the conduct of a member of Parliament as such could now be regarded as a breach of privilege, even if it were calculated and intended to bring pressure on the member to take or to refrain from taking a particular course. But any attempt by improper means to influence or obstruct a member in his parliamentary work may constitute contempt. What constitutes an improper means of interfering with members' parliamentary work is always a question depending on the facts of each case." End of quote. The February 18th video of Anonymous said that in respect of my honorable friend, quote, "You will cease your efforts immediately. If you do not, you will soon find yourself not only mocked, but jobless and despised," end quote. The video went on to suggest that he, my honorable friend, quote, "is bound to have many skeletons in his closet. Some of these have already been brought to light, and we have no doubt that this is only the tip of the iceberg," end quote. The video later inferred that he would not be allowed to, quote, "have any secrets of his own," end quote. The February 18th video also included a broad swipe at all honorable members by threatening, quote, "Let this be a warning to any politician. Your actions will not stand. You cannot run, you cannot hide," end quote. In a subsequent video published on February 22nd, after disclosing a number of items of personal information in respect of the honorable member and of individuals close to him, Anonymous rhetorically asked, quote, "Do we have your attention? How does it feel to have personal information about your family in the hands of people you know nothing about, with no control over who disseminates it or how it will be used? Let it be known this is only a taste of the information we have access to, and this is only the beginning," end quote. Later in the video, there was another broad threat to all members of this House. So I suppose that this very intervention I'm making will come within the ambit of this threat, to the effect that, quote, "To the rest of the Parliament of Canada, you would do well to mind your words about Anonymous," end quote. Mr. Speaker, in the most recent video on February 25th, a further threat to the honourable member for Promonjay was uttered to the following effect, quote, "You have 7 days to reflect upon your personal and political crimes. After that, the Canadian people will also be made aware of just how disgustingly unscrupulous and corrupt you are," end quote. As I will review later, there have been false and misleading statements meant to malign the honourable member. We should expect more of the same. In this weekend's video, there was yet another threat aimed generally at all honourable members. Quote, "And to the," excuse me, Mr. Speaker, "and to the rest of you who support Bill C-30, do not believe for a moment that you are untouchable. Anonymous has received information implicating many of you, both in political and personal scandals. Let the next 7 days serve as a period of reflection for the entire House of Commons. Ask yourselves, how many more scandals can you afford?" End quote. To summarize the various quotes, Mr. Speaker, they are more than just intimidation or threats. Quite frankly, they are blackmail. In a ruling on September 19, 1973, Mr. Speaker Lamoureux on page 6709 of the debate stated that he had, quote, "No hesitation in reaffirming the principle that parliamentary privilege includes the right of a member to discharge his responsibilities of a member of the House free from threats and attempts at intimidation," end quote. Mr. Speaker Bosley on May 16, 1986, at page 13362 of debates, held that the threat or attempt to intimidate cannot be hypothetical, but that it must be real or have occurred. For his part, Mr. Speaker Perrin on March 24, 1994, at page 2705 of the debate said, quote, "Threats of blackmail or intimidation of a member of Parliament should never be taken lightly. When such occurs, the very essence of free speech is undermined. Without the guarantee of freedom of speech, no member of Parliament can do his duty as expected," end quote. In that instance, a prima facie breach of privilege was not found because the threats were associated with an appeal then pending at the Ontario Court of Appeal. Page 143 of Erskine May says that, quote, "The House will proceed against those who obstruct members in the discharge of their responsibilities to the House or in their participation of its proceedings," end quote. Indeed, Mr. Speaker, your own decision on December 13, 2011, at page 4396 of the debates, also turned on the principle of whether there is an impact on parliamentary duties. This brings me, Mr. Speaker, to whether or not these threats arise from a, quote, "proceedings in Parliament," end quote. The circumstances before us today arise from Bill C-30, which was recently introduced, as you know, and which now sits on the order paper as an order of the day. Pages 91 and 92 of O'Brien and Boss quote two definitions of this term, proceedings in Parliament, from Erskine and May and Australia's Parliamentary Privileges Act 1987. Mr. Speaker, May's definition states that, quote, an individual member takes part in a proceeding usually by speech, but also by various recognized forms of formal action, such as voting, giving notice of a motion, or presenting a petition or report from a committee, most of such actions being time-saving substitutes for speaking, end quote. The Australian statutory definition contains the expression, quote, all words and spoken and acts done in the course of or for the purposes of or incidental to the transacting of business of a house, end quote. Page 80 of Mango addresses the point that, quote, two of Parliament's constituent elements, the House of Commons and the Senate, were established for the enactment of laws. Those events necessarily incidental to the enactment of laws are part of, quote, the proceedings of Parliament. Mr. Speaker, the introduction and sponsorship of a bill cannot get closer to the process of enacting a law. Therefore, I would submit that the threats and accusations are quite clearly relating to a proceeding of Parliament. While I'm making references to Australia, Mr. Speaker, that is in one case from the Commonwealth with shares features to this case, and particularly as regard the generalized threats to all honourable members. On May 4th, 1993, the President of the Australian Senate ruled at page 19 of Hansard on two related questions of privilege. On one of the matters, the President said, quote, the essence of the matter raised by Senator Walter is that a person has allegedly threatened to publish certain supposed information concerning opposition members of Parliament if the opposition members adopt a certain policy in relation to X-rated videos, end quote. The subsequent 43rd report of the Committee on Privileges in December 1993 described the threats identified by Senator Walters as, firstly, an alleged threat, quote, to out Liberal Party figures if the party adopted what it claimed was a leaked policy document proposing a sex industry crackdown, end quote, and secondly, an accusation regarding a, quote, potential release of security film of a coalition member at a sex shop, end quote. The President found that, quote, the possible contempt of Parliament contained in the matter raised by Senator Walters is that of seeking by threats to influence senators in the conduct of senators. This is one of the well-known contempts of Parliament. The alleged threat is directed to opposition members generally and not to any particular person, but it is well established that the threat to unnamed members or to a group or category of members or to members in general can be a contempt just as can a threat to particular members be. The alleged threat as reported is also directed to opposition members of Parliament generally and does not distinguish between members and senators. If the threat as reported were made, it could be regarded as being directed to senators as well as members of the House of Representatives. This is so particularly having regard to the fact that senators could and probably would participate in the formulation of any policy relating to X-rated videos. The formulation of such policy by a group of senators clearly falls within their duties as senators and their conduct as senators. A threat such as the one reported obviously has the potential substantially to obstruct senators in the performance of their functions, end quote. In the event, after hearing submissions and evidence, the committee concluded that in the event of further details it acquired, this particular case, quote, did not have the effect or tendency of substantially obstructing senators in the performance of their functions, end quote, although the committee did find the actions of those responsible to be, quote, inept and offensive, end quote, and part behavior which was, quote, cavalier and unprofessional, end quote. Mr. Speaker, one area I should address is the identity or source of the threats and the ability to make a specific charge. Citation 99 on page 26 of the Beauchesne states that, quote, direct threats which attempt to influence members' actions are undoubtedly breaches of privilege. They do, however, provide serious problems for the House. They are often made anonymously, and it is rarely possible for the House to examine them satisfactorily, end quote. In a September 1973 ruling, Mr. Speaker, Lamoureux found at page 6709 of the debates that the incident raised by a member could not be a prima facie question of privilege because the member did not know the identity of the person at the other end of the telephone conversation which gave rise to the complaint. Nonetheless, the unknown identity of those responsible for breaching privilege did not deter Mr. Speaker Milliken in his October 15, 2001 ruling at page 6085 of the debates from stating, quote, there is a body that is well equipped to commit such act of inquisition, and that is the Committee Standing Committee on Procedure and House Affairs, which has a fearsome chairman, quite able to extract information from witnesses who appear before the committee with the aid of the capable members who form the committee of the House, end quote. Now, Mr. Speaker, I have no doubt that the honourable member for Eldon, Middlesex, London is an even more fearsome inquisitor than his predecessor 11 years ago. I believe that the same principle about the role of committee holds equally true today. That is to say, any unanswered questions can be resolved there. As so far how one could start to get to the bottom of this, I have some thoughts. I am sure that others do too. However, my prevailing thought is that it should go to a committee to sort out this approach, hear from appropriate experts, and go from there. Mr. Speaker, I would commend to you the decision of your immediate predecessor from October 6, 2005, at page 8473 of the debates. The chair wrestled with a novel question related to a new statutory and standing order provisions pertaining to the Ethics Commissioner, and that the Officer of Parliament's conduct in respect of an investigation of the honourable member for Calgary East. In those circumstances, Mr. Speaker Milligan opined that he was prepared to find a prima facie case of privilege, quote, to afford the House an opportunity to pronounce itself on how it wishes to proceed, end quote. Indeed, Mr. Speaker Jerome asked in his March 21st, 1978 ruling on page 3975, quote, does the act complained of appear at first sight to be a breach of privilege? Or to put it shortly, has the member an arguable point? If the Speaker finds any doubt on the question, he should leave it to the House, end quote. Mr. Speaker Lamoureux also took this perspective of the member getting the benefit of the doubt on October 24th, 1966 at page 9004 of the debates, and on March 27th, 1969 at page 853 of the journals. In the present novel circumstances, sir, I think the same course of action is equally appropriate. Mr. Speaker, before concluding, I want to turn briefly to the other source of contempt in this argument: the unjust damaging of a member's name as constituting an obstruction. In the February 22nd video, Anonymous accuses the honourable member for Promontory through an inference by using sarcastic language of nepotism in respect of an employee of a member of the other place. Again, on February 25th, it was said that, quote, it is widely known that you engaged in criminal activity to further your political career as you did in 1999, end quote. Let's be clear, Mr. Speaker. The honourable member has not been convicted of any criminal offence. These statements are not only misleading, but are false and can only be viewed as an attempt to discredit the reputation of our honourable friend. Mr. Speaker Fraser's ruling on May 5th, 1987, at page 5766 of the debate, stated, quote, the privileges of a member are violated by any action which might impede him or her in the fulfillment of his or her duties and functions. It is obvious that the unjust damaging of a reputation could constitute such an impediment. The normal course of a member who felt himself or herself to be defamed would be the same as that available to any other citizen. Recourse to the courts under the laws of defamation with the possibility of damages to substitute for the harm that might be done. However, should the alleged defamation take place on the floor of the House, this recourse is not available, end quote. Nonetheless, Mr. Speaker Milliken issued several rulings with respect to the damaging of a member's reputation, including some decisions with respect to mailings by a member into another member's constituency, as well as the previously mentioned case on comments made by the Ethics Commissioner. Given this departure from Mr. Speaker Fraser's view, but more so the inseparable nature of the accusations from the threats contained in the videos published by Anonymous, I would submit that the Chair should find this to be a further ground for finding a prima facie case of privilege. In closing, Mr. Speaker, the Chair is faced with a case where those of legitimately held concerns about some business before Parliament have gone about expressing their opposition and seeking to secure actions in view with their thinking in an utterly despicable manner. Mr. Speaker, extortion and blackmail are not part of legitimate debate. Threats against MPs to vote one way or else are unbecoming of the Canadian political discourse. But Mr. Speaker, not only are they awful and inappropriate, they cross a line. They are a contempt of this honourable House. The ancient privileges of Parliament were first meant to secure the independence of members' actions free of the interference of the Crown. They subsequently broadened to encompass freedom from interference regardless of the source. As an institution, we cannot allow this reckless and irresponsible behavior to go completely unchecked. The first step, Mr. Speaker, would be to find a prima facie case of privilege, so that the Honourable Member Provencher can offer his motion to refer the matter to a committee, where the facts can be investigated and the issue studied, so that we may, as a House, respond to such behavior now and in the future. Thank you, Mr. Speaker.